A big day tomorrow in the Karen Reed case. The continuation of the hearing, which was originally scheduled for last week, but was suspended in the middle of the hearing due to Judge Cannoni's grave concerns for the defense and the defense attorneys. So we are going to be seeing what happens tomorrow. Join us here at Brother Counsel Studios, February 25th, 11 a.m., when we will be live streaming that hearing, and I will be giving you my real-time analysis of what's going on during that hearing. Should be a very interesting day, and hopefully will clear up a lot of confusion and speculation that was going on the past week. In the meantime, the defense filed a motion to strike another expert witness from the Commonwealth. So we are going to be going into this motion today, and I'm, of course, like always, going to give you some of my thoughts about this motion and perhaps something that maybe could have beefed up this motion a little bit to maybe eventually get a win and victory in this specific request that they're making to exclude this expert witness, or, of course, alternatively, they're asking to have a Daubert-Lanigan hearing. So here we go. Let's pull up the motion, and we will go through, like we always do, just parts of it to get the flavor of it, and then I'm going to be jumping into the analysis. So here we go, and this was filed by Robert Alessi. Seems like Robert Alessi is taking over in terms of the expert witness stuff. So he's been very involved in the expert witness stuff. So that's fine. And he definitely is entertaining and good and effective and very interesting to listen to and argue. So here we go. And we all, as you know, I also enjoy his writing style. So we're not going to see a lot of snark in this motion, but we will be seeing some bits and pieces of it. Okay, and here we go. Now comes the defendant, Karen Reed, and respectfully moves this honorable court to exclude the testimony of Robert Gilman. And you see how he refers to Robert Gilman as a Mr. Gilman. That just may be a little subtle attack right there. Concerning the hardness of the ground in and around the lawn area of 34 Fairview Road in Canton, Massachusetts, in the evening of January 28, 2022, and the early morning of January 29, 2022. Now, this is very important. Why is it important for the Commonwealth to have an expert to opine about how hard the ground was when John O'Keefe was allegedly murdered there? Well, the reason is that you have to figure out, you have to explain the blunt force trauma that was to the back of his skull. Now, how did that happen? How did that occur? It wasn't through Karen Reed backing her car into his head. That was very clear. So the question is, according to the Commonwealth, how did that happen? Well, only one of two options. Either he fell on the curb and smashed his head on the curb, or he fell on the ground, but the ground was so hard, it was so frozen, so hard, that itself, just that trauma was enough to cause that injury to the back of his skull. Now, you see how Robert Alessi put lawn area in quotation marks? He's doing that purposely. He's doing that for a reason, because that is a term, apparently, that you see in this expert's report. That's why he's coining it that way. He's putting it as lawn area, referring it to the same way that the expert referred to it. And we're going to see why that he has some issue with that. Okay, that is, Mr. Gilman is not qualified to render the opinion on the subject of the hardness of the ground that he proffers. Neither Mr. Gilman nor the Commonwealth has put forth any information regarding Mr. Gilman's qualifications to testify as an expert about the ground's hardness and the requisite geology, hydrogeology, and other like scientific precepts necessary to opine on the supposed hardness. So they're saying Mr. Gilman is just simply not qualified. Now, remember, there's two different attacks when it comes to a Daubert-Lanigan hearing. The first attack is whether the person is qualified. Does this person even have the requisite knowledge, experience, and training to even be considered an expert in this field? That's number one. Number two is that even if you are an expert, what type of methodology did you use in this specific case to come to your conclusions or come to your opinions? So the first thing that Robert Alessi is saying is that, number one, Mr. Gilman is not qualified. His qualifications simply do not mean that he's qualified in this specific area. Now, again, like let's say you're a doctor. So you're definitely qualified as a doctor, but let's say what you're trying to testify about is engineering. Well, then, you can't testify about engineering even though you're a doctor. You have to be qualified in the subject area that we're talking about. So he's arguing here that the hardness of the ground is not something that Mr. Gilman is qualified to render opinion about. That's number one. Number two is the methodology. So let's see what he says about the methodology. Additionally, the Commonwealth has failed to satisfy the methodology prong of the Daubert-Lanigan analysis because Mr. Gilman proffers no methodology of any kind in his report. or in any of the other materials supplied by the Commonwealth. So number 2, he says there's simply no methodology at all. What type of methodology did he use to come to his conclusions about how hard the ground was? Now, again, Robert Alessi is arguing there's no methodology. We saw Hank Brennan argue that there's no methodology for Dr. Me Russell when there clearly was. So it's possible, most likely, that Hank Brennan's going to respond and say, what are you talking about? Of course there's methodology, and this is exactly the methodology that he talks about. But Robert Alessi is arguing, obviously, that there's no methodology. All right, let's continue. Now, who is Mr. Gilman or Dr. Gilman? Mr. Gilman received a Bachelor of Science degree in meteorology from Pennsylvania State University in 1979. Mr. Gilman's curriculum vitae lists 7 different work experiences, including his current roles as chief meteorologist for precision weather forecasting and New England weather science, positions he has held since 1980. So his current role is that he's the chief meteorologist. So he's definitely a meteorologist. He's qualified in meteorology, and he's held these positions since 1980. None of the information contained within Mr. Gilman's CV pertains to the fields of geology, hydrology, and I don't know why they didn't put in here hydrogeology, but okay, or any other relevant scientific field related to the study of the ground in any sense, especially not the hardness of the ground. So you may be a meteorologist. You may be the best meteorologist in New England. Doesn't matter. Point is that does a meteorologist mean that you have the expertise to opine about the hardness of a ground? So continuing with the argument, let's talk about Mr. Gilman's report. Mr. Gilman's report is devoid of any substance which could even be liberally construed as a methodology of any kind for reaching its conclusion related to the condition of the ground. The full extent of the information on the subject of the condition of the ground in the lawn area, which is most likely the area that he referred to, of 34 Fairview Road in Canton, Massachusetts on Saturday, January 29, 2022, from all of the materials provided by the Commonwealth related to Mr. Gilman is as follows. So it's devoid of any substance, and the full extent of the information is the following. The typical lawn area would have been hard as a rock due to frost below and freezing of soil. As the proponent of the claimed evidence, the Commonwealth must prove by a preponderance of the evidence, meaning more likely than not, that Mr. Gilman's methods and processes behind his opinion are scientifically reliable. The Commonwealth-induced defect with the application of his legal principle to the present facts is that Mr. Gilman has no method or process behind his bare opinion that even hints at scientific reliability. Mr. Gilman's opinion that the ground was hard as a rock cannot be reasonably viewed as anything other than mere unsupported speculation and a subjective belief. Beyond failing to describe any semblance of a methodology in any of the submitted materials, and by the way, unfortunately, we're not able to see what the report is. He didn't attach it, or at least if he did attach it to this motion, I didn't see it. And maybe it's not available to the public, but he's talking about his methodology, which is in his submitted materials, and he says that it fails to have any semblance of a methodology. The Commonwealth and Mr. Gilman failed to show that Mr. Gilman's methodology, or lack thereof, is generally accepted by the relevant scientific community, is the subject of peer review, or a reasonable application of the purported methodology to the facts, conditions, and data of the particular instance. So that's part of the requirements to show, to satisfy Daubert, is that it has to be generally accepted, meaning the methodology has to be generally accepted by the scientific community. It's the subject of peer review, meaning it has to be peer reviewed, and or that it has to be the application has to be reasonable. There has to be reasonable application of the purported methodology to the facts, conditions, and data. So this all fails, he's arguing. Remarkably, neither the Commonwealth nor Mr. Gilman ever used the words generally accepted in any of the submitted materials. So he went through the report and he said, look, they didn't even use the right terminology. That's how far off base they are here. You got to use at least that the methodology that I'm using, or that is used in this case, has been generally accepted in the meteorologist community, or whatever other expertise community or scientific community that he's going to be referring to. And he didn't say that in the report at all. The scant material provided on the topic of ground hardness is unscientific on its face. Also, the inclusion of quotation marks around Mr. Gilman's description of the ground as hard as a rock is a tacit admission that this analysis is not scientific in and of itself. Hard as a rock is not a scientific analysis or a conclusion or opinion, probably. What's the standard of hard as a rock in the scientific community? It is a euphemism and a common figure of everyday speech. I mean, yeah, we use that in regular everyday speech. That's how laymen speak. That's not how scientists speak. How hard is that? Oh, it's hard as a rock. And what would be a little bit less than hard of a rock? A little bit less than hard of a rock? That's only hard as a softer rock. Like that's obviously not standards that are used in the scientific community. So the fact that he includes this in his report, hard as a rock, that in itself shows you that this isn't scientific. This just sounds like someone who's talking to his friend on the street. Oh, yeah, that was hard as a rock. The use of lay language where a scientific assessment should be extant is a further showing that Mr. Gilman did not rely upon a scientific methodology to reach his speculative opinion. And that's the reason why Robert Alessi is arguing that he should be excluded. That's just for these reasons, Dr. Gilman's failure to proffer a reliable methodology or any methodology at all on the topic of the supposed hardness of the ground precludes the Commonwealth from meeting the methodology prong of the Daubert-Lanigan inquiry. And in the conclusion, he says, after that, he says at the end, alternatively, they would be willing, not be willing, but alternatively, the court doesn't want to strike. All the way to the last sentence, if you take a look. In the alternative, should the court not grant the defense's motion on the papers to exclude Mr. Gilman on his lack of qualifications and his lack of methodology or reliable methodology, the defense requests an evidentiary hearing to establish the failure of the Commonwealth to meet its Daubert-Lanigan burden regarding the ground hardness testimony of Mr. Gilman. So here we go. We have another, essentially, alternative to ask for a Daubert-Lanigan hearing. So we have, first of all, we have Mr. Crosby. That's another one where he asked to exclude Mr. Crosby or have a Daubert-Lanigan hearing. And here we go again, asking to exclude this Robert Gilman and or alternatively have a Daubert-Lanigan hearing. So now we have two potential Daubert-Lanigan hearings that have to happen before this trial, which is on April 1st. We're scheduled to begin April 1st. And again, a lot of it's going to be dependent on what happens tomorrow, I think, also. So we'll have to see what happens tomorrow, which is what I think everyone's waiting for, to see really what's going to be going on with this trial going forward. Now, there's something that I want to talk about in this motion, which I think could have been very helpful for Karen Reed. And it's something that I talk about a lot. And some of you who have already been watching this channel for a while already know exactly where I'm going to be going. And that is, if you can show that there's no case law that allows a meteorologist to talk and opine about the hardness of the ground, that is what you need to show. Now, there is an expertise, at least from my Googling, that I saw where there are experts that can talk about how hard the ground is, called geotechnical engineers or soil engineers. And they deal with ground, I guess, and they deal with how hard the ground can be due to frost or ice or snow. So there are technically experts out there who can opine about this. Now, the question is whether a meteorologist has the expertise to testify about it. Now, in my research, what I've discovered in Massachusetts is that I've only found cases which allow meteorologists to talk about snowfall and how cold it was and at what time how cold the weather was, and you just how much snowfall there was and precipitation, things like that. I have not seen, and again, I didn't do an extensive research on the topic, but I have not seen ever in any case in Massachusetts where a meteorologist is allowed to opine about how hard the ground is. And therefore, what I would have said, if this was my motion, I would have said, and one of the first statements I would have said is that there is no case, there is no law in Massachusetts that allows a meteorologist to testify about the hardness of the ground. And if there is a case out there, then I would ask the Commonwealth to provide that case, because in my research, I have not found that case. And therefore, if there is no case like that, then that's a good indication that in Massachusetts law, a meteorologist cannot do it. Are we going to create new law now to say that a meteorologist could testify about the hardness of the ground? Maybe they can make a case, but it'll just make your argument that much stronger to say, Your Honor, I did some research, I did some due diligence. I tried to be complete as much as I can with my brief writing, and I didn't find any case that says that a meteorologist could testify about the hardness of ground. Yes, they can testify about how cold it is outside, how much snowfall there was, how many inches of snow was on the ground, and precipitation, and weather patterns. Sure, that's fine. That's all fair game. We see that straight out in the case law, but we just haven't found the case that says the meteorologist could testify about the hardness of the ground. It just simply doesn't exist. And if it does exist, and you don't have to be as strong about it, you can say, look, I did my research. If the Commonwealth can point to a case that shows that meteorologists could testify about the hardness of the ground, well, then the issue is done anyway, because they can say, look, this case says specifically that meteorologists could testify about the hardness of the ground. And then, okay, well, what are we going to argue? We're going to argue that they can't have this expert? I mean, the case law is clear in Massachusetts. So I think that would have been made their motion a little bit stronger. Not just talk about the Daubert-Lanigan standard, which is a lot of the quotations here to the authority in this motion, but also just simply do the next step and say, you haven't found anything like this that allows them even to do what they're trying to do. And that always just gives your motion a little bit more of a bite, makes it stronger. And it really puts the onus on the other side to do some research, some real good research, to find some case law that you are not able to find. And if they're able to find the case law, by the way, okay, then good. So then that's what the law is. Can't fight against the law. That's what the law is, and then that's what has to happen. So it's not like you're calling a bluff, and then if they find it, then you look silly. Look, you say I did my research, couldn't find it. They can find the case, great. They can have the witness. Can't find the case, well, then they shouldn't have the witness. So you're putting the responsibility on them. If they want to call this witness, and they have to show that Massachusetts law allows this witness to testify to what they're asking the witness to testify to. So. And that's what's going to be with this motion. So we have to see what Hank Brennan responds. I'm sure he's going to argue that there is methodology here, and he's going to argue that meteorologist is qualified to testify about the hardness of the ground. But I think, to me, it all comes down to show me the law, show me the case, make some inferences, you got to do some good research, legal analysis. And if you don't find exactly specifically where meteorologists could testify about the hardness, then you better make some good comparisons to some other experts where the judge, the court did allow this specific expert to testify about the hardness of the ground, and the meteorologist to be similar to that. But there's got to be some more legal research done on this and presented by the Commonwealth, I think. And if they don't do that, if they don't cite a case, then what you have to do by this hearing, whenever this hearing is, then your first argument to the judge is, Judge, they make some great arguments, but unfortunately, the law in Massachusetts is that meteorologists can't testify about the hardness of the ground. There's no case like that. So unless Your Honor wants to make new law right now, as we're sitting today in court, and no judge wants to do that, by the way, then it's simply the Massachusetts law just doesn't allow it. So that's what my position would be on this case if I was on the Karen Reed side. So we'll see. Okay, there's still more to see. We have to see what type of research the Commonwealth has. Maybe they can find a case like that, or maybe they can make some good comparisons. So to other cases that allowed experts to testify. So that's going to be it for this specific motion. Hopefully we'll see you all tomorrow. Again, February 25th, 11 a.m., right here, Brother Counsel Studios. We will be live streaming the hearing. A very, very interesting hearing. We got to show up. We got to see what's going on. And of course, we'll do some legal analysis on it as well. So that's going to be it for now. If you haven't, please subscribe, like, and we will see you next time.